Katie, thank you so much for being a perennial sponsor of ours, and we appreciate your support so much. Please tell us what's going on with TrueView inspection. What's changing in the industry right now? Is the surge that we're experiencing affecting how you conduct business? We'd love to hear everything that TrueView is doing at the moment. Thank you so much for sponsoring the class.
Absolutely, Kevin. Thank you so much for having me. I hope that everyone could hear me okay. I am doing this remote today from a real estate event, so I'm super happy to be sponsoring today's class. A little bit about TrueView in today's market and what's happening. I think that more than ever, time is of the essence, and when dealing with these real estate transactions. And today I'm going to tell you a little bit of what makes us different and how our company can help you, especially when time is crunched like today's trend of the real estate. So number one, we have immediate report delivery. So no more waiting for a couple hours to receive that full home inspection report. The next day, you and your client will receive the full home inspection report to your email immediately before the inspector leaves the property. And this just is great when time is of the essence. Number two, we have HD pictures and videos with all our reports. So they say a picture is worth 1,000 words. Well, imagine how many words a video is worth. And all our full home reports come with HD pictures and videos. And number three, we have a 200% satisfaction guarantee. So for whatever reason your client is not satisfied within receiving the report within 24 hours, we're not only going to refund their money, but we're going to go ahead and pay for a subsequent inspection up to the original value that they paid with us. That's how confident we are. We would love to be one of the companies that you refer to your clients for inspections. We always include the appropriate insurance reports with the full home inspections. That way they're set to go and there's no more delays and you get to the closing table faster. I'm going to go ahead and leave our website in the chat. We also have an online scheduler that's available to you and your clients to schedule inspections 24/7, which makes it very convenient. It has real-time availability, real quote, you get it scheduled in. And there's a little discount there available right now. There's a discount code available to save your clients some money. So I'm going to leave our phone number, our website. I'm going to stick around for just a few minutes. I know you have a very important class to attend to, but should you have any questions, I'll be here to help.
Can you talk about the specifics about the discount real quick? What does it give them? And you're putting it in the chat, correct?
Yes, I'm going to go ahead and put it in our chat. There is a discount code. I'm not sure what it is. I think it's Save 10 or Save Summer, something there. And it will save them on full home inspections. We also have a buyer's protection guarantee, which means for whatever reason, this crazy market, if the first deal does not go through and not able to go through with the first home purchase, we give a $100 discount for the second inspection. And fingers crossed, let's hope that they find their future home and get settled in.
Those are some incredible offers. Thank you for sharing us today. Please be sure. I cannot talk today. My goodness.
That's okay.
Please be sure to put the promo code in the chat. And then also, how long is the promo code good for?
It will go until the next promo code is uploaded. We'll always have a promo code available on our online scheduler. Okay,
so it'll be. Will it still be available when I send out the video either later this week or beginning next week?
Absolutely.
All right. So if you don't copy it down in the chat, I will do my best to include it when I send the video recording.
Perfect.
Thank you. Thank you so much, Katie, for always sponsoring, for always being present, for always telling us about the amazing thing TrueView does for us realtors. Thank you so much.
Thank you, Kevin. Have a great class, everybody.
You too. And with that, with no further ado, we have the incredible Chief of Legal at MIAMI REALTORS, Shahr. The floor is yours. Thank you so much for volunteering for this class.
Thank you, Kevin. So I'm going to go ahead and try and share my screen now, if that's okay.
Sorry, I had to stop my share. It should work now.
Okay, let me move this over. And let's see. Oh, nope, I don't want to do that. I'm slightly technologically challenged, everyone. Just give me a moment. All right. Okay. So let's start. So this is actually going to be a two-part program. There are so many legal issues facing the real estate professional industry these days that I broke it up into two segments. So today we're going to be focusing on part one, and then in September, we will host part two. So I do have to provide a disclaimer. All of the information presented today is for informational and educational purposes only. The information does not constitute individual legal advice. Please consult with your own legal counsel on your specific situation and any specific legal questions you may have. The information provided in this webinar does not create an attorney-client relationship with the presenter. So here are the topics. Part one, today we're going to do a general overview of fair housing. We're going to talk about buyer love letters and source of income ordinances, fair housing and the relationship between fair housing violations and criminal background checks, antitrust compliance, current condominium disclosure rules under Florida law, changes to the National Association of Realtor Code of Ethics, Section 10-5, copyright and trademark compliance. I will give you a latest news update, which includes an update on the Department of Justice versus NAR lawsuit, the eviction moratorium, and the new Florida Association of Realtors escalation clause addendum. We'll wrap up, do a couple of case study examples, and leave it open for Q&A. Our next session, which will be held sometime in September, will focus on part two. And part two will include ADA and website compliance, FRET complaint and violations of NAR Code of Ethics procedures, the presumption of transaction brokerage and what exactly that means, E&O insurance, cybersecurity, emotional support animals, and another update of what's going on in the news on the legal front. Let's start today with fair housing. So what are the federal, state, and local fair housing laws? Well, our Federal Fair Housing Act prohibits discrimination in the sale, rental, and financing of housing based on the following protected classes that are underlined and in red. The Fair Housing Act protects people from two types of discrimination. This is very important to know. It protects those from intentional discrimination, but it also protects those against discrimination that has what we call a disparate impact against a protected class. So you may not be intentionally discriminating, but you may be engaging in a policy or practice that has the effect of having a discriminatory effect on one of the protected classes. And there's your definition of disparate impact. Here's an example. A housing provider violates the Fair Housing Act when the provider's policy or practice has an unjustified discriminatory effect, even when the provider did not have an intent to discriminate. So what is prohibited? I just have given you a huge list here of examples. These are things that you want to watch out for and stay away from. You cannot refuse to sell or negotiate for housing. You cannot otherwise make housing unavailable to certain groups of people and not others. You can't set different terms, conditions, or privileges for the sale or rental of a dwelling. You cannot make, print, or publish notices, advertisements, or statements with respect to the sale of housing that indicates any kind of preference or limitation or discrimination against any of the protected classes. You may not discourage the purchase of a dwelling. You may not assign a person to a particular neighborhood or section of a building, and you cannot deny access to or membership in any MLS or real estate brokerage organization. There are more examples on this list, but those are just a few of the highlights. We also have a fair housing law here in the state of Florida. Our Florida fair housing laws mirror the federal fair housing laws. They're exactly the same except for one addition. Under Florida law, discrimination on the basis of familial status applies to any person who is pregnant or in the process of securing legal custody of an individual. We also have a Miami-Dade County Fair Housing Ordinance. And Miami-Dade County follows the Federal Fair Housing Act. However, there are many other protected classes under the Miami-Dade County Ordinance. In Miami-Dade County, you cannot discriminate either directly or have a disparate impact on those on the basis of ancestry, pregnancy, age, marital status, gender identity, gender expression, sexual orientation, source of income, meaning Section 8 vouchers or other sources of income, including Social Security, disability, or actual or perceived status as a victim of domestic violence. There are severe penalties and damages if you violate the fair housing laws. The Federal Fair Housing Act, the first citation penalty is $21,663 for your first violation. Federal Fair Housing Act violations can be reported directly to HUD, and HUD will then investigate the matter. If there is a fair housing violation, the individual that has been the subject of the violation can also file a lawsuit against you or your brokerage or agency in federal court because it is a violation of federal law. They may also allege that not only did you violate the federal law, but you violated the local county ordinance and the state law. So you can be hit with not only the money penalty from HUD, but also the attorney that is filing the action can, if they succeed and if they prevail on the lawsuit, they are then awarded all of their attorney's fees. You would have to pay those attorney's fees and costs, in addition to actual damages and the penalty that is assessed either by the state or by HUD. Part of being in compliance with fair housing laws at a local level includes being in compliance with our local source of income ordinance. We have one here in Miami-Dade County, there's one in Broward County, and now there is one in Hillsborough County. So anyone that is practicing in the Tampa area, now you have a source of income ordinance as well. This makes it illegal to discriminate, for example, against any individual based on their source of income. So if the individual is paying for housing with a subsidy or any kind of assistance, like a Section 8 voucher, a HOPWA program, or any other benefits program, including Social Security, disability, that would include source of income. And for a complete list of what is considered source of income in Miami-Dade and Broward counties, and other tenets of the ordinance, I have listed the actual statute sections on this slide. It would really behoove you to take a look at the ordinances and see what it covers, what the damages are, what the penalties are for violation, and what types of source of income it covers. More on this issue on a national level. Recently, a watchdog group in New York, the Housing Rights Initiative, has taken action against various real estate entities in New York. The group has filed suit in New York State Court against 36 realtors, brokers, and landlords, including Keller Williams Realty and a franchise of Century 21. They are alleging source of income discrimination in this lawsuit. This watchdog group spent 8 months running a systematic testing program, auditing both landlords and realtors to weed out discriminatory agents and practices. This is happening all over the country, including here in Miami-Dade, Broward, Palm Beach counties, and across the state of Florida. Please be aware of fair housing laws and regulations, and please familiarize yourself on our source of income ordinances so you are not caught in this type of situation. On the right-hand side, there is an example of a text message that they were able to retrieve that is part of the lawsuit. It reads, "Hi, my name is Deja Carter. We just got off the phone. You told me to text you. It would be for a family of 5, and we have a voucher. It says we can look at 3 bedrooms up to $3,200. The response from the realtor is the following. hello, Deja, I managed to get a hold of the owners and they declined subsidized housing assistance because of the paperwork that must be submitted. Sorry, I'll keep you posted of any other listing. This is a prohibited practice. You cannot refuse to rent a dwelling unit because the individual is using a Section 8 voucher to pay. It doesn't matter if you haven't been certified yet as a Section 8 landlord. In this situation, if you are not certified yet, you still cannot say, I can't accept it because I'm not certified. You would have to, if this individual tenant is able to pay the rent that you are asking, and this is a true candidate that meets all of your financial criteria, meaning the amount of rent that your client or customer is requesting, you would then need to go through the process to fill out the paperwork and become an actual Section 8 approved landlord. It is not too arduous of a process to do so. The bottom line is you cannot say, no, we do not accept Section 8. That would be prohibited. Buyer love letters. This is a potential fair housing minefield. And in today's age, where it is extremely competitive, we have little inventory, we have individuals moving here from all over the United States that want to purchase a home or rent an apartment. This practice is becoming increasingly common, and it is extremely dangerous from a fair housing perspective. Buyer love letters are used in an attempt by some buyers to stand out and entice a seller to choose their offer. The problem is that buyers will reveal personal information in these letters and characteristics about themselves, such as their race, their religion, their familial status. These are all protected classes. So the information contained in the letter could be used either knowingly or unknowingly to select one individual over the other. Here's an example. Consider where a potential buyer writes to the seller that they can picture their children running down the stairs on Christmas morning for years to come in the house. This statement may seem innocuous, but this statement not only reveals the buyer's familial status, but also their religion, both of which are protected characteristics under fair housing laws. And using a protected characteristic as a basis to accept or reject an offer would violate the Fair Housing Act. Bottom line, stay away from buyer love letters. Educate your clients and customers about the fair housing laws and the pitfalls of using a buyer love letter. Inform your client or customer that you will not deliver these letters, and advise others that no buyer love letters will be accepted as part of the MLS listing. If your client insists on doing this, do not help your client draft it or deliver it, and explain to them the potential fair housing violations. And as always, in any situation, document all offers received and seller's objective reason for accepting an offer. I also would like to encourage all of you to visit Fairhaven. Fairhaven is a fair housing simulation that has been brought to you by the National Association of Realtors. You can learn how to avoid fair housing pitfalls through interactive examples. This will only take you about 1 hour to complete. It's a wealth of information and knowledge, and it will serve to protect you and your brokerage from fair housing violations. Screening tenants. I get this question quite a bit. How do we stay within the law and still screen tenants? Well, as far as criminal background checks go, doing a criminal background check is not per se illegal. But remember that the criminal background check policy must be based on a substantial, legitimate business justification. And you cannot have a criminal background check policy that may cause a disparate impact on one of the protected classes. Why? This is because research has shown that members of certain protected classes, such as Black and Latinx or Hispanics, and people with disabilities are more likely to be arrested and convicted than members of other groups, despite committing crimes at similar rates. So criminal background policies that may have a disproportionate impact on these groups would be a violation of fair housing laws. Here's the guidance from HUD. It's in quotes. Where a policy or practice that restricts access to housing on the basis of criminal history has a disparate impact on individuals of a particular class or race, that policy is unlawful if it is not necessary to serve a substantial, legitimate, non-discriminatory business interest of the housing provider. So let's unpack that a little bit. Very simply, treat everyone the same. Watch out for excessively restrictive criminal background checks that could have a disparate impact on a protected class. If you have a criminal background check policy, you must apply it equally to all applicants. You cannot require background checks for some groups and not others. And housing providers cannot reject an applicant with a disability who has a criminal background, but accept a tenant without a disability who has a similar criminal background. You must be very careful in the use of these criminal background check policies. In 2006, HUD did come out with guidance on this specific issue. This guidance addresses how discrimination can be shown in fair housing cases when an adverse housing action is taken based on a person's criminal history. Remember, those with a criminal record are not a new protected class, and it doesn't prohibit a housing provider from considering criminal records. But what it does prohibit is housing providers using arrest records alone as the sole basis of a housing decision, or blanket broad-based policies such as, we want only those with a clean background. Please, no arrests, no convictions, no criminals. Do not use those words. If you use those words, you are now setting yourself up for a fair housing lawsuit. It also prohibits housing providers from using those criminal records as a pretext for intentional discrimination, or in a way that results in a disparate impact. All right, on to our second topic of the day, antitrust compliance. Oh, here comes that problem broker. Let's agree that we won't do business with him. Sure, okay, let's do it. Can't do that. Antitrust violation. Why is awareness and sensitivity to antitrust laws essential for real estate professionals? Well, here's why. Real estate and housing issues are of great interest to our government. Real estate professionals are operating in cooperation and competition with one another. This presents opportunities for antitrust violations. If you are unaware of the laws and you have a lack of knowledge, this could lead to costly litigation and sometimes very extreme consequences like criminal penalties, harsh fines, and massive triple damages. Here's an antitrust example. Broker 1 and broker 2 are talking at a local association meeting. My overhead is killing me. I'm going to raise my listing fee. What are you charging? Same with me. My rent just went up and I can barely make ends meet. I heard broker 3 is actually cutting their commissions, making it really hard on the rest of us if they lower their commissions. Do you think we can do something about this? Can't have that conversation. That is an antitrust violation. Here's an overview of antitrust law and what this actually means. Antitrust laws are designed to safeguard competitive free enterprise by prohibiting actions that damage competition. Antitrust objectives are twofold: provide consumers with low prices and high quality that flows from competition, and provide a level playing field for the entrepreneurs who are vital to achieving competitive business markets. There are several laws that combine to make up our federal antitrust laws. The first one is known as the Sherman Act. The Sherman Act states that every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade is declared illegal. So simply put, it means that it is illegal for two or more people to carry out a plan that will restrain trade. So let's break this down. It's a conspiracy of two or more people. So for example, after analyzing profits and costs, broker one decides to set the firm's commissions at 5%. Broker one's agreement to set their commissions is not considered a conspiracy because broker one is acting as an individual within their own brokerage firm. So that is not a violation of antitrust laws. However, if broker one attended a real estate seminar with broker two and several other brokers where they discussed their worries about profits and cost and agreed that they should set commissions at a certain rate, that would be an antitrust violation because now you have a conspiracy. You have two or more people agreeing to take action to restrain trade. Agreeing to take action. What does that mean? Please remember that agreements do not need to be explicit, or be in writing, or be formal to violate antitrust laws. So if you're talking about any of these issues, which you should not be talking about any of these issues because a wink, a nod, a raise of the eyebrows in agreement, listening to one of these conversations about how different brokerage firms are setting different commissions or how you want to set your commissions or this guy's doing this or that person's doing that. Just listening to that and allowing that conversation to go on in your presence is a potential antitrust violation. So in this example, it's just a nod of a head. Broker said, yeah, that's a great idea. We don't want to deal with discount broker because he's only advertising a 2% commission. Great idea. Let's not deal with him. Broker one and broker two are two competitors. So there's a conspiracy. There's two or more people. Now they've agreed to take action to restrain trade. That's an antitrust violation. Generally, realtors are found to be restraining trade when engaging in one or more of the following actions: setting or fixing commission rates. This is basically what all of the previous examples have been about, except for the example on choosing not to deal with a specific broker, and that is known as boycotting, which is also a violation of antitrust laws. But you can't make any agreement with any of your competitors on what price or fee you're going to charge customers for products or services. That is a violation. You also cannot negotiate commission splits or referral fees that a firm will pay for goods or services that you receive instead of the fees that you charge your client. So competing brokerages, if competing brokerages are agreeing to fix the compensation that will be paid to cooperating brokers for producing a buyer for a listing, that would be a violation. Now, listing and selling brokers may discuss or negotiate the compensation with respect to an individual transaction. But real estate professionals need to avoid the implication that there is an agreement to uniform or standardize the industry practice as to how the commission would be split. There is no standard commission. There is no standard commission split. Real estate commissions are negotiable. I'm going to say that again. There is no standard commission. There is no standard commission split. Real estate commissions are negotiable. Group boycotts, also a violation of antitrust laws. This is just an agreement among your competitors not to deal with another person or another business collectively or to exert pressure on them because they are doing something that you don't like. Here's an example of a group boycott. This is the example that I used a couple of slides ago, right? Broker 1 is complaining to broker 2 in a room full of realtors that discount broker is advertising 2% commission rates. Broker 3 chimes in and says, well, I don't do business with that broker. Broker 1 nods his head. Then broker 1, broker 2, their conversation is overheard by other brokers. No one says anything, but 16 other brokers, because of this conversation, return home and now refuse to do business with discount broker. Flagrant violation of antitrust laws going on. Tying arrangements. This is an agreement to sell one product, but on the condition that the buyer also purchases a different product or service. You cannot tie agreements together that restrain trade in the industry. So although this is not a conspiracy because it wouldn't be two or more that are acting together, this would be, for example, if you are a broker and you own a property that a builder wants to buy. And as part of the sale, you tell that builder, I'm not selling you my property unless you relist the property with me when you sell it. Now you're requiring the builder to list the property with you as a condition of you selling it to them. That's considered a tying arrangement or a tie-in agreement, and it is unlawful under the antitrust laws. Market allocations. Market allocations are when competitors agree to refrain from selling in specified territories, selling specified services or products, or selling to specified customers or categories of customers. These agreements restrict competition because firms should be free to sell and list property in any market area and to any customer that they wish. Division of territory. Under antitrust laws, competitors cannot agree to limit service areas. Firms must independently determine the market area for their services based on the merits of selling to that market territory, not on the basis of a predetermined agreement with a competing firm. Now, an individual office may assign sales associates to work specific territories. This is a practice commonly known as farming. This is totally legal because this is an individual firm and it is considered one entity and individually as one entity, not in consultation with other entities, but only within that one firm, they can devise methods to effectively cover their entire market territory. You also cannot pre-allocate customers in with competing firms. So competitors cannot divide or allocate the customers to whom they will sell. How are antitrust laws enforced? The federal government, through the Department of Justice, enforces federal antitrust laws. The Federal Trade Commission also enforces antitrust laws. The DOJ will initiate both civil and criminal enforcement proceedings, and the FTC enforces laws through civil complaints, and they can levy substantial monetary penalties in addition to issuing orders to limit or prohibit offending business activities. At the state level, our state attorney general and our local DA's offices enforce state antitrust laws through both criminal and civil actions. And we also have a private enforcement right of antitrust laws. So federal and state laws grant private parties the right to enforce these laws. That means that the lawsuit does not have to be brought by the DOJ or the state. It can be brought by an individual that seeks damages in civil court. Penalties. The penalties are very severe. A violation of the Sherman Act is a felony. If convicted of an antitrust violation, you can be sentenced for up to 3 years in prison, and it imposes individual fines of $350,000 or twice the economic gain or loss for each violation. An individual or agent of a corporation who is convicted of an antitrust violation may be punished by fines of $5,000, 1 year in jail, or both, even without actively participating in the prohibited conduct. Liability under antitrust laws can result from passive acquiescence or ratification of illegal activities. Bottom line, stay away from all of the previous examples that I have mentioned in this presentation today. There are injunctions and cease and desist orders that can be levied. And in extreme situations, the government may seek to dissolve or disband a business entity, and individuals or organizations who prevail in civil lawsuits are entitled to receive 3 times the amount of their actual damages, as well as attorney's fees and costs. There are state, criminal, and civil penalties as well. Avoiding antitrust violations, how to make sure you're in compliance. Educate yourself on these laws. Stay away from having any of these conversations. The nature of the real estate business, with its constant interaction between industry competitors, makes it easy to violate these laws if you are not aware. Awareness is vital. Every real estate professional is affected by these laws. Here are some recommendations. Have an antitrust policy in your office. Have every office member read and acknowledge receipt of the policy. Give every office member a copy of the NAR's pamphlet, Antitrust Compliance Guide for Realtors and Realtor Associates. Include antitrust training as part of every new salesperson and broker training. Include realtor ethics training as a part of that same training. Establish a relationship with competent legal counsel, and please seek legal advice before you take any action whenever you are unsure of what the law requires. Here's a brief review of the antitrust laws: the purpose, the law, how an agreement is found, and when there has been a restraint on trade. And this is just a summary. We've already gone through these points. All right, moving on to the next hot topic, and something that is very, very germane to what has happened recently with the Surfside tragedy and the questions that I have been getting about required disclosures for condominiums. So the Florida Condominium Act is codified under Chapter 718 of the Florida statutes. Please be aware of the following. A potential purchaser of a residential condo is entitled at the seller's expense to a current copy of the following: declaration of condominium, articles of incorporation, bylaws and rules of the condominium, the most recent year-end financial statement, and the FAQ or Q&A condo sheet. Please also be aware that the seller doesn't have to provide any of the above unless the buyer asks for it. So you, as the real estate professional, need to know the law, because you need to know what you are able to ask for. And once you ask for it, what the seller must provide under Florida statutes. These are some questions that I advise buyers ask. Access to a building's 40-year recertification documents, if applicable. Buyers should have their title agent order what we call a municipal lien search. A municipal lien search will pull up any unrecorded code violations. Please be aware that a title commitment alone does not pull up any code violations. Code violations are not recorded until they become liens on the property. That could take years. So if there are any code violations on a property, either with a condominium or a single family residence, you have to order a municipal code violation search in order to pick those up. They will not show up on a title search. Same with open permits, which is not on this list, but open permits do not show up on a title search. You actually have to do an open permit search in the municipality for where the property is located. The buyer should ask if there are any special assessments coming up. They should ask for a copy of all of the condo governance forms, as I said in my previous slide. They should ask for the condominium meeting minutes for the last year. They should ask if it's applicable to your individual customer or client, if the condo meets the guidelines set by Fannie Mae. Does the condo association own the land on which the condo sits? Meaning, do they own the land in fee simple, or do they own the land on what we call a ground lease? This is important for financing purposes. Check to see if the condominium association is party to any pending litigation. So a litigation search should be done as a part of ordering title and the municipal code violation searches and the open permits. And does the condominium association have any engineering reports? And please, please use the FAR, Florida Condo Association Disclosure Form Rider. It is there to protect the buyer. It requires a lot of information from the seller. It also requires the seller to certify that, that they are not aware of any special assessments, that there's nothing in the meeting minutes. So it puts the onus on the seller to certify these things. It also has in there information on if a condominium association has a right of first refusal to purchase and how that needs to be, how that procedure needs to be followed. Remember that if you don't exercise one of these condo riders, and there is a right of first refusal by the association, in the condo rider, it very clearly says that if the condo decides to purchase the unit and not allow the buyer to purchase the unit, meaning they've opted to exercise their right, the condo rider clearly says that that buyer's real estate agent still gets their commission. If you don't use the rider, then there's nothing under Florida law that says definitively if that buyer's agent is part or the cause or the procuring cause of the transaction, and now you're caught in the dispute. So make sure you use the rider. It is there to protect the buyer. It is also there to protect the seller so that the seller knows what disclosures they are making and what they are certifying. What do you look for in these association documents once you get them? It is recommended that an attorney review the documents with the buyer. It's important to look for things like the estimated life expectancy of major components, such as the roof, the pool, the parking lot, paint, elevators. Then review the reserves. This is why it's important to get the financial statements from the condominium. You have to gauge whether or not there are sufficient funds to cover issues that may arise based on the life expectancies of these components. There are very clear definitions in these condominium documents on what is considered a common element and what is considered a limited common element. Common elements are normally the responsibility of the association. Limited common elements can either be the responsibility of the association, or that responsibility can be thrust upon the owner. So it's important that you read the declaration to see what you're responsible for and what the association is responsible for. And it's always important to get a copy of those minutes, because you can read those minutes and you can monitor if there were any areas where the association, for example, opted out of maintenance or updates. For example, all condominiums that are 3+ stories must be retrofitted for fire sprinklers. If the association in its minutes opts out of that, then there was a recorded board vote on the matter. This means that as of now, the building voluntarily is not up to fire code. So these are some of the things that you wouldn't know about unless you get a copy of the minutes and read the actual governing documents of the condominium association. Now we're going to move on to an overview of the new National Association of Realtor Professional Standards Policies on Discriminatory Speech. There's a new standard of practice. It is called 10-5. It changes the definition of public trust, and it adds a standard of practice that prohibits discriminatory speech by real estate professionals. So the standard of practice was adopted on November 13th, 2020. And here's what it says. Realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So it takes the federal protected classes and it also adds in sexual orientation and gender identity. The standard of practice flows from the requirement to not deny equal professional services or to be party to a plan to discriminate. So bias against protected classes, which was revealed through the public posting of hate speech, could result in realtors not taking clients from certain protected classes or not treating them equally. And this is a violation of the Fair Housing Act. So it's not about types of speech subjectively deemed offensive or discriminatory by one person and not another. It's based on particular types of speech that are directly connected to the following protected classes. For example, harassing speech. Harassment includes inappropriate conduct, comment, display, action, or gesture based on another person's sex, color, race, religion, all of the other protected classes. And these can be verbal examples. They can also be nonverbal examples. NAR also defines what is considered another example of harassment, which is not limited to epithets, slurs, or negative stereotyping. This includes threatening, intimidating, denigrating jokes, the display or circulation of written or graphic material that denigrates or shows hostility toward an individual. And the NAR has also provided an Appendix 12 to Part 4 in the Code of Ethics and Arbitration Manual with additional guidance on explanations on what the definitions of harassment, hate speech, epithets, and slurs would be. These are definitions that they provide. These are also the Merriam-Webster's definitions of epithets or slurs and the definition of hate speech. So to find out if someone has violated 10-5, it's a two-step process. Is the speech harassing speech, hate speech, epithets, or slurs? And then if so, is the speech based on one of these enumerated protected classes under 10-5? It is an objective, not subjective analysis. We must have clear, strong, and convincing evidence. The burden of proof is on the complainant to provide the information. and context is taken into consideration. NAR also changed the definition of public trust. Everybody listen to this. The applicability of the Code of Ethics now applies to a realtor in any situation, not just in their real estate transactions. So the information that is stricken is what they took out. And what's left is basically, it says applicability of the Code of Ethics. A realtor shall be subject to disciplinary action under the Code of Ethics with respect to all of their activities. What does this mean? It means if you're at a restaurant and somebody hears you say something which is considered an epithet or a slur or hate speech, you could be in violation of 10-5 of the Code of Ethics. And there's the final version. Applicability of the Code of Ethics. A realtor shall be subject to disciplinary action under the code with respect to all of their activities. So the rationale for this, they didn't want it just tied to a real estate activity or transaction. They were seeing realtors engaging in discriminatory and abhorrent conduct and speech, and this expands the applicability to all of a realtor's activities. Here is a disciplinary guideline example. So what happens if you are found in violation of 10-5? There needs to be a complaint. The complaint would be filed with the local board of which that realtor is a member. The complaint then would be heard by the grievance committee. The grievance committee would decide if there is enough evidence on the face of the complaint where there could be a violation of the Code of Ethics. Then that case is sent to an ethics hearing, where a panel of your peers will decide, after they hear the testimony and evidence of both the complainant and the respondent, if there is a violation of the Code of Ethics, and then sanctions will be imposed if they find you in violation of the Code of Ethics. So here's an example. In social media discussions, Realtor C posted several discriminatory and offensive comments, which were deemed to be in violation of Article 10, as they discriminated against individuals on the basis of. In determining appropriate discipline, the hearing panel considered Realtor C's comments as hate speech and discrimination in violation of Article 10, and had reason to believe that a violation of the public trust occurred. Based on this, the hearing panel recommended a $5,000 fine and mandatory completion of implicit bias training. The local boards can also impose fines of up to $15,000 per violation. They can put a letter of warning, or even more severe is a letter of reprimand, in your file, which remains in your file for a period of 3 years. And they can also require completion of various educational and ethics courses. Note, we also have another standard of practice in our Code of Ethics, and this is Standard of Practice 3-11. This deals with realtors cannot refuse to cooperate with other realtors on the basis of a broker's race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. And Code of Ethics complaints can also be filed against respondents for violation of this standard of practice. Okay, context matters. There is no list of words or phrases that would result in an automatic violation of the code. And the changes are not retroactive. These changes went into effect this year, January 1st, 2021. But Standard of Practice 10-5 applies to conduct occurring November 13th, 2020 and thereafter. Okay, copyright issues in the real estate profession. We've got one more topic and then we'll open it up for questions. Copyright infringement. This is another source of contention in the realtor world and the subject of lawsuits. Make sure you own the right to your photographs. If you don't own the right to your photographs or you don't have a proper license for that right, you can't use them. Copyright law applies to any unique artistic expression, including videos, music, illustrations, and of course, photographs. You have to get written permission from the person that owns the rights. If you can't reach the owner of the right, then just don't use the image. Be mindful when you engage a photographer or other creative professional, you must read the terms of their contract. If they don't have one and you don't get a work for hire agreement that gives you the rights, you are only buying a copy of the photo and they are then retaining the rights. Use your own images or get a service that offers images you may use for a fee. Claiming that your website was developed by a third-party vendor who selected photos is no excuse. If you own the website, you're liable for the violation. The same is said for listing photos in an MLS. The listing agent and the listing broker are responsible and thus liable for the photos in their listings. For example, the Miami Association of Realtors multiple listing service policies and procedures prohibits members from uploading photos containing watermarks, as well as photographs that are not copyright protected. Trademark violations. This is something we see a lot in the legal division. We see violations of the National Association of Realtor-owned marks. Please be careful when using the terms realtor, realtor associate, realtors, or realtor. These marks are owned by the National Association of Realtors, and they are intended for use by NAR members and member boards in connection with your business. But you must use the marks in accordance with what we call the NAR Membership Marks Manual, and I have a link there to it. If you have any questions on how you are using your mark, please feel free to reach out to me. It's better to send me an email if you have a question, is this in compliance, than to get a cease and desist letter from our office. Okay, we're going to go through just a couple of educational examples here. This is a topic that we haven't covered today, but it's about disclosures in residential transactions. And this is one of those hot button legal issues that comes up all of the time. So let's look at scenario one. A potential buyer is especially concerned about the risk of termites at a property you're representing. She asks if the home has ever incurred any damage from termites, to which you respond, no, none. But you fail to mention that there has been evidence of the presence of termites on the property in the past, though they've never caused any significant damage to date. If the aforementioned potential buyer ultimately buys the home, then months later starts to see termite damage and wonders why, they will likely come back to you and blame you for failing to disclose the presence of termites. So the seller and the listing agent could also be potentially liable, even if failing to disclose the termites was not an intentional act. So other common related items that an agent can get in trouble for not disclosing include foundation issues, improvements made without permits, or leaks. Common misrepresentation issues also include property boundaries or issues with roofs, or even an agent's relationship to the buyer, seller, or anyone else involved in a transaction. So what's the lesson here? Disclose, disclose, disclose. We have a standard FAR seller disclosure form. Use it. And if your seller comes to you and asks you whether or not they should disclose something, the answer is always disclose. You will always be on the right side if you disclose the issue. If you know of something, just disclose it. Otherwise, you may be faced with a situation or a lawsuit down the road. Here's another scenario for you, the mishandling of funds. Your buyer is thrilled with the perfect home you've helped them find. And you meet up on a Friday afternoon to collect their earnest money for escrow. You take their check, put it in a safe interior pocket in your purse, and promptly forget all about the check until you notice it in your purse the following Tuesday. Remember that earnest money needs to be deposited into escrow in a timely fashion. Agents should not take this lightly. Avoid moving money around, not keeping up your books, or borrowing money from clients, which is a major no-no. Bottom line, when handling clients' money, keep it organized, get it to the appropriate parties as quickly as possible. And our last scenario for the day, here is an example of an ethics violation of Article 3. An agent calls you regarding a property you've listed, which currently has an accepted offer with contingencies. The agent wants to know what the status is on offers and contingencies, and you reply, "I'm not at liberty to discuss." Now, you may not know this, but Article 3 of the Code of Ethics states that realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. This obligation to cooperate does not include the obligation to share commissions, fees, or to otherwise compensate another broker. As such, you are obligated to disclose if an offer has been accepted and what the current status is in case the agent and their client wants to submit a backup offer. Please communicate, talk with one another. If an agent calls you, call them back. You may not think that these things are violations of the Code of Ethics, but many times they are, depending on the facts. And I guess I have one more scenario here. I forgot about this one, but it's a very important one. It has to do with what we know as steering, which is a fair housing violation. Your clients are shopping for homes in a new city and want to know the crime rates in different neighborhoods to help them make their home buying decision. So you generate crime reports with a variety of crime statistics on every neighborhood in the city, and you provide them to your client. This is not how this should be done. Such practices that might potentially sway a buyer towards wanting to live in one neighborhood versus another, that is considered steering under the Fair Housing Act and under the NAR ethics guidelines. So to avoid this potential slip into steering, agents need to do things like this. Suggest listings to clients based on a home's objective features and price points, and then refer the client or customer to a third party if they have questions about things like schools or ethnicities in the neighborhood. And this can be as simple as just pointing the client to internet resources so they can learn about the information themselves. But directly providing this information is a no-no. All right, so that is the end of part 1 of our legal series. For more information, my contact information is there for you. You can email me at any time. And Kevin, I think we probably have maybe about 5 or 10 minutes to open it up to questions if we have any.
Absolutely. And if you don't want to put your face on screen or use your voice, just put it in the chat and I'll recite it back to Shahr. Okay, I'm sorry if you've already answered this. The first question is from Christine. Is there a limitation period for misrepresentation by a seller?
So she's asking if there is a statute of limitations, and there is. I just can't remember the exact time frame. It's either 2 years from actually knowing about the misrepresentation or finding out about it, or 3 years. But I will have to get back to you on the actual statute of limitation time.
Thank you, Shahr. The next question is from Kevin Kruger over in the commercial board. Kevin, thanks for joining us today. His question is, could NAR assist our federally trademarked brokerage firm with enforcing cease and desist demands that were sent to other NAR members nationwide?
So I'm not sure exactly what this individual member is talking about. I'm guessing that they got a cease and desist letter for the improper use of a realtor mark, but I'm not sure who they got the letter from. So
Kev, do you want to elaborate? Sorry to cut you off there, Shahr. Kev, do you want to elaborate on the story so she can provide a better answer?
Can I clarify? It's Kevin Kruger.
Please do.
Having a hard time. Okay, great. Shahr, my brokerage firm is Rise Realty. We're federally trademarked with the USPTO about 8 years ago. And since that time, there's about a dozen copycats of Rise Realty. Most recently in Palm Beach County, we sent a cease and desist. They complied promptly, but there's Utah, Illinois, Massachusetts, all with the Rise Realty trademark. I'm wondering if NAR could support NAR members like my firm in asking the other copycats in these other states to cease and desist.
So I'm not sure is the answer. You know, I can't speak for NAR. I would have to speak with their general counsels. But in general, my thought would be, since it's not a violation of any of the NAR owned marks, but rather a violation of a mark that you have federally trademarked, that you would just need to continue to use your own legal counsel to send out your cease and desist letters. The good news is that you do have a federal trademark. So as long as it's in the same class, you know, under federal trademark laws, you have certain classes that you register under. So if these other organizations are impeding on the same class that you've registered under, you know, the same business, you know, getting your own attorney and sending out those letters is really what you need to do, which it sounds like you're already doing that. Whether or not NAR can assist you in that process, I'm not really sure.
Understood. You can imagine the legal expenses are virtually cost prohibitive, and we'd rather be brokering than counseling. But thank you both. I appreciate that. I might send you an email if I could.
Sure, no problem.
All right, thank you.
If you don't have her email, just hit me up. I'll send it over to you. It's actually Shahrzad at MIAMIRE.com.
I see it on the screen. Thank you both.
For sure. Anytime. Thanks for joining us, Kevin. All right. The next question is from Nancy, and it looks like it's a simple yes or no question, but I could be wrong. Is the seller's disclosure a mandatory document with the sale/purchase of residential real estate?
It is not. It is not mandatory at all. So it is not required under Florida law that you use that seller disclosure form. That's a pretty easy question. We do recommend it though. We recommend that you use it, but it is not a requirement.
Perfect. Okay, the next question comes from 20 under 40 winner, Daniel. Daniel, I'm not even going to attempt to say your last name. I'll wait to hear it when I meet you in person. But the question is, if the landlord doesn't want to rent to college students just because they are college students, I've actually been a victim of this, and she believes they will cause trouble, will that be considered discrimination? Their parents are rich and are co-signing the lease.
So college student is not a protected class. So unless the behavior by not renting to college student now has what we call a disparate impact on a protected class, then it likely would not be a violation of any fair housing laws. So for example, if all college students in a certain zip code are whatever, one of the protected classes, right? Or of one particular race, for example, And that landlord is now refusing to rent to college students, which now has the trickle-down effect of him actually refusing to rent to college students, all of which whom are X. That then would be a potential fair housing violation. But college students are not a protected class.
I have a follow-up question to that. My case is a little different. It's long ago, I don't care. But he said that he'd rather rent it out to females because us rowdy boys probably would trash the house. That would be a violation then, correct?
Yes. Yes, that's gender.
I wish I would have known that 15 years ago. Okay, next question. This one is from Barbara. And Barbara asks, can an agent use dates on the lease form for longer than 1 year?
So the Florida Association of Realtor U.S. Supreme Court approved lease agreement is only 1 year in length. So if you modify it, you are now engaging in the outside practice of law, which is prohibited. So if you want a lease that is longer than a term of a year, you can do it. But if you're going to modify the promulgated lease form, you do need an attorney to make that revision. But leases in Florida, residential leases in Florida, are allowed to be longer than 1 year in length. It's just that our Florida residential lease form that has been approved by the U.S. Supreme Court is only 1 year. So if you modify that, then you would need an attorney to do so.
Very good. Okay. Kayla Revelis, I'm sorry if I said your last name wrong, Kayla. Do you want to pop on? You have your hand raised.
Yes, I do. You actually said it right. Thank you. Thank you so much for putting this together. It was very informative. I had a question. It was in regards to the condos. I didn't really understand that slide. What I've been realizing, I have clients that are interested in purchasing, well, buyers that are interested in purchasing in HOA areas. However, oftentimes I see that they don't accept FHA financing. Is that something that's common?
Yeah, so this is actually an area that MIAMI, our government affairs team, is actively working on. We really believe that the FHA prohibition on certain areas, it's actually, I think, all of Miami, where they are requiring more of a deposit. They require a larger deposit in certain areas of the country. Based on your zip code, really. And we believe that that is a potential fair housing violation. So we are in communication with HUD, and we plan to continue to pursue this because it is directly impacting our buyers here in Miami-Dade County. And it's almost prohibiting many of them from purchasing their first home, which might be a condominium, because of these FHA restrictions.
Okay, that's great to know. Thank you so much.
You're welcome.
Okay, the next question is from Phil Calloway. It's actually a follow-up question from Daniels about the landlord refusing to lease to college students. And he asks, as a follow-up question, isn't age a protected class?
Yes, that is correct. Now, not all college students are, I mean, you can be going to college and you could be 40, right? I mean, so you would basically, like I said before, you would have to do the analysis. Because the landlord is saying no to college student, does that then have a trickle-down effect on one of the protected classes? So if in that particular area, all of the college students are the same age, and now you can make that link, then you may have a fair housing violation. I didn't use age as an example, I used race, but you could use any of the protected classes as an example.
Very good. Okay. The next question is from Nancy. And the question is, this is a hot topic, by the way. This is all about service animals. When does a tenant have to disclose that they are bringing a service animal into a rental? And then she has in parentheses, of course, in a rental that has indicated that they do not want pets. So no pet deposit could be collected.
Right. So there's a difference between saying no pets and no service animals. Service animals are not considered pets. So an association or a landlord could very well say no pets, but that doesn't mean no service animals. Now, if the landlord says no service animals, that's a violation. But if they say no pets, that doesn't mean that a tenant can't bring a service animal. So, you know, if I were an attorney representing that tenant and it just said no pets, but I brought my service animal, I would argue that it's not a violation because I don't have a pet. I have a service animal.
Excellent. Okay. I'm not, Mina, you might need to clarify. I'm asking your question next. Please let me know if you can elaborate. She asks, how about a minimum age requirement? I don't know if that's in relation to the landlord question that we just had. Mina, can you provide a little more info? I see you're off mute. Go ahead and speak.
Yes, so I was basically just piggybacking your previous question about the age restrictions or requirement for the rental. So you just referred to like a older age students, but can you make like a minimum age of 18 years old or something like that? Is it a violation?
Well, I don't know if you're saying, I mean, you can't legally rent anywhere unless you're of age to legally bind yourself, which is 18 in the state of Florida. If you're younger than that, you need parental consent. So I don't know if you're talking about a restriction on like, oh, we don't want families with teenagers, or we don't want families with children or something like that, because that would be a fair housing violation. And I'll go back to these protected classes so that you see the list. But familial status is a protected class.
I see.
So let me go back to the list just so you guys can see it. We went through a lot of information today.
And this is just part one, guys.
This is just part one. There's so much more to come. There you go. So this is Miami-Dade counties. So it's all the protected classes in addition to this. So it's race, color, national origin, sex, disability, familial status, and religion. Now in Miami-Dade County, these are the additional ones: ancestry, pregnancy, age, which is what Kevin brought up. Now note, age is not a federally protected class. It's just a protected class in Dade County. Marital status, gender identity, gender expression, sexual orientation, source of income, and actual or perceived status as a victim of domestic violence.
Beautiful. Thank you for that. The next question is actually a follow-up to the service animal question. It's from Nancy again. And her question is this time, so when does the tenant need to say that the service animal is coming? The landlord knows that they have to allow them, and also that they cannot collect a pet deposit for that service animal.
Yeah, I'm getting you the Florida statute section here. So the statutory section here, let me get to it. Okay, it is Florida statute section 413.08. And I alert you to this statute because this is our law here in Florida regarding service animals. It defines a service animal. And I'm just looking to see if there's any type of notice requirement under this statute. I don't recall that there is, but I would have to read the statute and see if there's an actual time frame or notice requirement where the individual tenant has to notify a landlord that they're bringing a service animal. I'm not sure that there is one, but again, that's the statutory section. You can take a look at it. And if you send me an email, I will look at it as well and I'll get you an answer.
Once again, that email is Shahrzad, at MiamiRE.com. Shahrzad, I believe.
That's right.
Thank you. The next question is from Yvonne, and this one's for me. Yes, there will be a copy of this presentation. And Shahr, if you don't mind sending me the PowerPoint, I'd love to include that as well.
I will do that. Yep.
Thank you so much. The next question comes from Gladys. And her question is once again about not HOAs. So it is about HOAs, but it's also about support animals. Can an HOA reject an applicant with an emotional support animal or pet?
No. No.
But they might find a reason, correct?
Yeah, I mean, they may find a reason under Florida statutes to do so, but in general, if they are rejecting you just because you have an emotional support animal, that would be improper.
Very good. Thank you. The next one is from Karen, and let me know when you got to go, Shahr. There's a few more though.
Okay.
Is age, if age is a protected class, what about 55 plus communities?
So that's an exception to the fair housing laws. You are allowed to have 55 plus communities as long as they abide by certain federal statutory requirements. So as long as you, and I think it's either that you have to rent at least 80% or sell at least 80% of the units to those 55 and up, or you have to have at least one person that is 55 and up occupy the unit. But as long as you meet those requirements, that's an exception to the fair housing laws.
Very good. Okay, the next question is from Nikki. Can a landlord restrict the number of occupants?
The landlord can restrict the number of occupants as per code. So if the zoning code requires there be no more than X number of occupants, then the landlord can restrict the number of occupants because they would be doing so in accordance with the local ordinances.
Very good. Okay, the next question is once again from Daniel, 20 under 40 winner. His question this time is, if he receives a great offer of $530,000 with an escalation clause up to $535,000 and another offer at I'm so sorry, everybody, $540,000, but the terms don't look as strong, is there an ethical way to gently let the first offer know that they need to step up their game with the price without violating the code of ethics?
So I don't really know quite enough from that example to give you an answer, but I would say that based on just from what you've told me, that just sounds like a negotiation, just a standard negotiation. I mean, you're perfectly permitted in representing your seller to try and get higher offers based on what you've already received. So going back to one buyer and saying, hey, I have a better offer, can you match it, or can you come up, or you're not high enough, or they'd like to take your offer, but this other offer has better terms, or your offer has better terms, but it's lower, so can you come up? I mean, that's just the name of the game. I don't see anything unethical about that.
Very good to know. The next question is from our president-elect of Miami YPN, Shahr Etienne. What about situations where a listing says that they will pay selling agent more in commissions for full price offers? For example, paying 5% for a full price offer and 3% for a less than full price offer. Is this practice allowed?
So that's interesting. So I have not seen that. So what you're saying is that actually this is on the MLS?
Chandra, do you want to jump in and clarify?
Yes, yeah, it is on the MLS. I actually just closed representing a buyer where on the MLS it actually said that they would pay 5% for full price offers. We did not close at full price, so they only paid 3%. And the entire time I thought it was pretty crazy, but in this market, I just wanted to close. But
I would say that ethically that would be a problem if your buyer doesn't know, right? Because to me it seems like if you get a higher commission because the price is higher, that would seem to violate all sorts of rules having to do with dealing with the public, right?
right.
So,
And I've seen this. There's actually another listing in my neighborhood now where they're doing the same thing. So they're offering 4% for full price or higher, and
yeah,
3% if it's less.
that to me seems very sketchy. And it does seem to call into question lots of different areas of our code of ethics. So that's very interesting. I mean, maybe Chandra, if you could email me afterwards, I'd like some more information about what's happening with that, because that seems quite problematic.
Yeah, sure. I'll even send you the MLS listings,
Great.
the printout, so you can see it as well.
Thank you.
No problem.
Yeah, that also sort of seems like there may be antitrust violations there too. I mean, it's kind of like if it looks like a duck and walks like a duck and quacks like a duck, it's probably a duck. Like you're not really sure it's a duck, but it sure as hell sounds like it's a duck. So I worry about that on a couple of different levels.
Yeah, especially since one of the listing agents is also an attorney. Yeah, but we'll discuss further after this call.
we got bad apples. We got bad apples at the bar too.
Yeah.
We try and keep everyone legal, even the attorneys.
Very good. Okay. I believe, they just keep coming.
We probably just have time, Kevin, for one more.
Okay. I will go in the order that they were submitted. Of course, you can send Shahr your questions afterwards too. So the final question is, and I'm not familiar with this term. I'm sure you know. And Lenny, if we don't know, we'll need some clarification. What is in 718 for tenants, especially in fractured condos or others that have minimum restrictions to leasing?
So I'm not exactly sure what you're referring to. I mean, Chapter 718 is the Condominium Act, but I'm not sure what the question is.
Can you clarify?
If you could clarify.
Well, Lenny's, if you're here, we'll certainly answer your question. Still, is it cool for one more while we wait for her?
Or you, yeah, or you could email me too.
Very good. Very good. Okay. Final question is from Wendy. Can an association withhold approval of a buyer until the buyer signs a document stating that they know there will be building inspections and likely special assessments in the future?
So in this instance, the association is saying, what? We're not going to approve you unless you sign this separate document that says that there will be special assessments. Is that the example?
Correct. They basically presented that to the listing agent, who is irate because the contract deals with who pays, special assessments before, after effective date and closing, etc. And now they're telling the listing agent they won't approve the buyer unless the buyer signs something disclosing there may be assessments in the future due to structural inspections as a result of what happened in Surfside.
It's strange to me that they would require that, because once you close, you know, I mean, unless you change it by contract, the purchaser is going to be responsible for those special
course.
assessments. That's in the declaration of condominium. I mean, that's like if you own your unit and there are special assessments, you have to pay the special assessments. So I don't know if they're trying to just further cover themselves legally, like some sort of boot and suspenders approach to make sure that if there are special assessments, you pay them. I would have to look into that more because this is the first that I'm hearing about this. If you could send me an email with the example.
Sure. It sounds to me like you're right. I think the association is trying to prevent like a new buyer from saying a week from now or 2 weeks from now or a month, oh, you didn't tell me there were going to be assessments, you know, so that they don't want to hear new buyers be upset with them. But at the same time, the seller feels like the association is tortiously interfering with its contract because the contract says what it is and they should approve this buyer. And they don't want to present this addendum to the buyer to sign.
Plus, if you use the condo rider, it says right in there if there's going to be any special assessments. And it also says the seller either has knowledge that there are special assessments or has looked at the minutes and there's talk of special assessments in the minutes. So I don't know is the answer to that one, but I would really like an email with the example so that we can start looking at that issue because that seems problematic to me. And it sounds like I hope it's not happening everywhere, but it sounds like if it's happening, it may start happening in other places.
Can you say your email address, please, slowly?
Yes, it's Shahrzad, SHAHRZAD at MIAMIRE.com.
Thank you so much.
And thank you so much for everybody attending today. Shahr, you were fantastic. An hour in, we had only lost 7 people. So that shows you how captivating the material was today. If you have any follow-up questions, Shahr has announced that she will happily answer your questions via email. And of course, we will be providing a recording of this entire class so that you can refer back to the information. We do understand it was a lot and a lot more is coming. And we want you to be safe and successful. So that's why we put on these classes with Shahr. Shahr, thank you so much for your time. Do you have any final comments?
You're welcome. Thank you everyone for joining. It makes me really happy to see all of our wonderful Miami members here. And like Kevin said, you know, we're doing this for you to keep you safe, to keep you informed, to keep you knowledgeable so that you can really be the best that you can be and you can really go out there and just do your job, right? And not have to worry about these legal minefields. So thank you all so much for joining, for staying attentive, for hanging in there with me, and we'll see you again in about a month.
Excellently said, Shahr. I have one more announcement. We have our biggest event of the year up September 2nd. It is our RE Bar Camp. If you are a YPN Pro, it is free almost through the rest of the month. If you are not a YPN Pro and would like for it to be free, please join. However, we do offer an early bird special, and that will be $20 up until the next couple of weeks, and then it'll jump up to 30. So please sign up early. We're trying to save you money, not only in this class, but in events too. So if you have any questions about YPN or legal updates or anything, you can contact Shahr, you can contact myself, and be on the lookout for future classes. This was the final installation of our second series of the year. It looks like we'll be doing a third now that we have a wonderful volunteer like Shahr, giving us another opportunity to learn about the law and how we can stay safe and save our money, more importantly. So with that, thank you everybody for joining today. It means a lot that you come and attend our classes. This is the second class in a row that we've hit triple digits. So that's super exciting for the organization. Thank you so much. And until our next class, thank you so much and be great, everybody. Take care.
Give up on my way.